Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. This is my private Facebook group, which if you're in foreclosure, you'll want to join. We all help each other out with our foreclosures. Today we're going to give an update on Marlon's case, Marlon Lewis. He's out of Texas, so we can talk about his situation and what's happened and what he's going to do about it. Okay, so first of all, if you're new to this channel, Marlon filed a complaint in federal court. It was June of last year. June of 2024, he filed his complaint, and they removed it to the federal court. And as you can see, in July 23rd, they removed it. And his case, if you want to look it up in Pacer, is 424CV02727. And it's in the Southern District of Texas in the Houston Division. And Marlon Lewis versus SN Servicing and U.S. Bank. SN Servicing. Two different defendants. And as you can see, his case has been proceeding through the dockets. The last thing that was filed was a scheduling order dated 3/5/25, basically, which goes over when the trial will be conducted. Okay, so what's going on in his case is that they're trying to evict him while he's got this pending case going on. So they filed an eviction citation right here, which we'll look at in the eviction court, which is a different court. It's like the Justice of the Peace Court. There, see, U.S. Bank National Association as trustee of the Igloo Series. Well, they put Series 4 trust, but it's really Series 5 trust. I think they screwed up. That's a typo on their part. Anyway, interesting. And as you can see, they're saying here that they want to evict him. This was filed in the court on the 19th day of March, and which is just a few days ago. And he has a hearing coming up on April 8th, 2025 on this eviction. So, you know, that was kind of wrong of them to do this while he's got a pending case in federal court. So let's look at what he's going to file in the eviction court. He's going to file in eviction court a motion for abatement. As you can see, the proper heading is up there. Comes now Marlon Lewis, defendant appearing pro se, and respectfully moves the court to abate or cancel the eviction hearing scheduled for April 8, 2025, and to temporarily suspend these proceedings due to the ongoing federal litigation concerning the ownership of the property at issue. In support of this motion, defendant states as follows. Ongoing federal litigation. Defendant Marlon Lewis has filed a complaint for quiet title in the federal court for the Southern District of Texas under case number, as you can see here, involving the same property that is the subject of this eviction action and the same parties. The federal case is currently active, and a scheduling and docket order was entered on March 5th, which outlines key deadlines, including a trial date of November 17, 2025. Impact of the federal case on eviction proceedings. The ongoing federal litigation concerns the ownership of the property, which directly affects the validity of plaintiff's claims in the eviction case. The loose pendants filed by defendant on June 20th, 2024 provides a formal notice of the lawsuit and the dispute over ownership. Because the federal case will determine the rightful owner of the property, eviction proceedings in this court are premature and may lead to conflicting rulings. Upcoming court date. The court has set an eviction hearing for April 8, 2025. Defendant respectfully requests that the court abate or cancel this hearing, as the resolution of the federal lawsuit will directly impact the outcome of the eviction proceedings. Given that the ownership dispute is still pending in federal court, it would be improper and inefficient for this court to proceed with eviction at this time. Request for abatement. Defendant respectfully requests that the court enter or abate the eviction hearing scheduled for April 8th and suspend all further eviction proceedings until the resolution of the federal case concerning the property's ownership. The federal court is the proper forum for resolving the ownership dispute, and eviction proceedings should be stayed until this matter is fully adjudicated. Wherefore, the defendant respectfully requests that this court issue an order to abate or cancel the eviction hearing scheduled for April 8, 2025, and further eviction proceedings pending the resolution of the federal lawsuit concerning the property. Respectfully submitted. Okay, Exhibit A. Scheduling order from the federal case, entered on March 5th, 2025. Okay, so, and then there's the certificate of service, because he's got to serve the other side. Okay, and then you got your Exhibit A, scheduling order from the federal case. As you can see right here, this is proof that the case is still pending, and all these things have to be done. And then at the very end, it's signed by the judge. So it's here, a bench trial set for 9:30 on 11/17. So, I mean, they can't just go and evict you while you're in the middle of another thing going on. And then here's this proposed order granting the motion for abatement. Hopefully the Honorable Jason Dunn, who's the Justice of the Peace Judge, will actually sign this and prevent the eviction from happening. And the other thing he's going to do, besides file this in the evictions court, is file a motion for sanctions in the federal court. So let's look at this real quick. This is his motion for sanctions against the attorneys that are pulling this crap, okay? Motion for sanctions and notice of unauthorized communications. Comes now plaintiff pro se Marlon Lewis files this motion for sanctions and notice of unauthorized communications as follows. Introduction. Plaintiff respectfully moves this court to impose sanctions on defendants and their counsel for sending an unauthorized and misleading notice to vacate and eviction citation regarding the subject property while failing to establish legal ownership or standing. Plaintiff also notifies the court that defendants are attempting to circumvent this federal case by engaging in bad faith legal tactics. Such actions constitute an abuse of the judicial process and violation of both federal and state law. Factual background. On February 25, 2025, plaintiff received a notice to vacate from defendant's counsel, George Shearer of Rodati Berger Law Firm. I can't pronounce that right. Despite defendants failing to provide proof of legal ownership of the loan or standing to issue such a notice, this notice was sent while the present case is pending before this court, showing a deliberate attempt by defendants to intimidate plaintiff and force an unlawful eviction. A copy of this notice is attached as Exhibit A. On March 19, 2025, defendant U.S. Bank Trust N.A. as trustee for the Igloo Series 5 Trust initiated a forcible detainer action in Montgomery County, Texas under cause number 4EV97910 while this federal quiet title and wrongful foreclosure case was and remains pending. A copy of the citation is attached as Exhibit B. The state eviction action is based entirely on the substitute trustee's deed, which is the subject of this federal quiet title action. Defendants are attempting to secure a judgment of possession based on a disputed and void title, thereby circumventing this court's jurisdiction. Defendants have not produced any legally valid assignment of the mortgage or proof of ownership that grants them the right to issue such a notice to vacate. These actions are a direct attempt to mislead and harass plaintiff without legal justification. Legal arguments. Defendant's conduct violates federal litigation standards. Under the Federal Rule of Civil Procedure 11B, prohibits attorneys from making claims that are unsupported by facts or made for improper purpose. Defendants are sending threatening notices to vacate without proving their standing, which misleads plaintiff and undermines the authority of this court. Defendants are attempting to circumvent the court's jurisdiction. Under the Colorado Water Conservation District versus United States, federal courts have the authority to enjoin state court proceedings when a party is improperly attempting to sidestep federal litigation. Defendants are issuing notices and initiating proceedings in state court to avoid judicial scrutiny in this federal jurisdiction, as seen in Chambers versus NASCO. And then there's a footnote about that one. The notice to vacate and eviction citation are improper debt collection actions without legal standing. The notice to vacate and eviction citation are improper actions under the Fair Debt Collection Practices Act, FDCPA 1692, which prohibits debt collectors from making false, misleading, or threatening representations. See Hines versus Jenkins. That prohibits such actions. Additionally, the Texas Debt Collection Act, TDCA, prohibits threats or coercion in debt collection. Defendants have not proven ownership of the property, making this notice to vacate and eviction citation improper and unlawful. And if you're curious about the footnotes, they're right here. Chambers versus NASCO, in which the U.S. Supreme Court upheld sanctions including attorney's fees and expenses totaling nearly $1 million against the party and its attorneys. The sanctions were imposed for attempting to deprive the court of jurisdiction through fraud, filing false and frivolous pleadings, and engaging in tactics of delay, harassment, and excessive expense. The Hines versus Jenkins held that attorneys are subject to the FDCPA when engaging in debt collection activities, including sending demand letters or making efforts to collect a debt. The court emphasizes that the FDCPA applies to any communication that seeks to collect a debt, even when made by an attorney, and prohibits misleading or abusive practices in such communications. Defendants lack standing to issue a notice to vacate or eviction. Under Texas Property Code, a party seeking to remove a tenant or resident must have the proper legal standing. Defendants have not provided documentation proving ownership or legal authority to evict plaintiff, making the notice to vacate and forcible detainer action unenforceable. Attorneys should be sanctioned. The attorneys representing defendants, specifically counsel George Shearer of Rabati Berger Law Firm, are engaging in conduct that violates the standards set forth by Federal Rule of Civil Procedure 11B. By sending unauthorized and misleading notices to vacate in an eviction citation without establishing legal standing or ownership, they have knowingly participated in an effort to mislead the court and intimidate the plaintiff into unlawful eviction. The actions of defendants' attorneys constitute an abuse of the judicial process. Federal Rule of Civil Procedure 11B requires attorneys to ensure that any claims made in litigation are supported by facts and law. The continued filing of actions without legal standing and the effort to circumvent this court's jurisdiction reflect a violation of these rules. Plaintiff respectfully requests that this court impose appropriate sanctions on the attorneys for their bad faith actions, including attorneys' fees, costs, and any other penalties the court deems just. Sanctions are necessary to deter further misconduct and protect the integrity of the legal process. Relief requested. Plaintiff respectfully requests that this court order defendants to cease all eviction-related communications, impose sanctions under Federal Rule of Civil Procedure 11B for bad faith litigation tactics and abusive legal processes, including but not limited to attorney's fees, expenses, and any other appropriate penalties due to defendants' unauthorized communications and failure to provide proof of standing or ownership. Declare the notice to vacate an eviction citation improper and unenforceable. Grant any other relief that the court deems just and appropriate. Okay, and then you have your exhibit cover pages and the certificate of service, because I could always serve the other side a copy of this. Okay, guys, so you see what Marlon's up against, and everybody pray that he has a favorable outcome after he files these two things. And if you guys have any questions, you can send me an email to foreclosurehelp777@gmail.com or leave a comment below, and I'll be happy to answer your questions. Thank you for your continued support, and I hope everyone have a blessed day.